And he.
But what would you have known before trial?
Well, he would have, perhaps Valentin would have talked to him before trial.
Well, the implication certainly is that he wouldn't, since he wouldn't talk to you during trial, and only when he was on the stand and the judge, per the judge's order, were you able to talk to him. So let's assume that you knew his name before, you did know his name before trial. So what would you have gotten?
Well, if he had known that he would, I guess the difficulty for defense counsel, and it's all over the record that that the defense was, quote, back on its heels, trying to think on its feet.
Okay, how?
Well, because he said on the record, defense counsel says on the record that had access to him pre-trial.
But you wouldn't have had access because there's no showing that he would ever have spoken to you. You don't have any.
But he might have, and he didn't. They did have, his investigator did have access to the police handler.
Okay, so the defense attorney, you know by now what it is that he would have said because you had an opportunity to cross-examine him. So how were you prejudiced? What didn't the defense counsel do that he could have done?
Well, the other piece of the prejudice, too, is that it not only did it affect the trial preparations, but it misled the grand jury. I mean,
What? I'm sorry?
It misled the grand jury. I mean, here.
Misled the grand jury?
The grand jury.
That's a totally different issue.
It's a different issue, but it goes to I think to at
You
least.
have to, all different standards, different concepts apply.
Right.
You haven't argued that in your brief.
No, I didn't argue. Well, I did in this section, in the prejudice section, the prejudice in terms of trial
But
preparation.
that's a whole different concept.
It's a different concept. But it went to this witness was the entirety of the. This is a case with no evidence. This is a case of this testimony.
I thought your client's bloody prints were found
on
at the scene of the murder.
On the handle of the.
That's no evidence?
That's the only other evidence. Oh. That's the only other
Bloody
evidence.
fingerprints on the murder weapon?
That's the only other evidence.
But this is not a case in which the attorney was stunned to learn that there was the statement of Mr. Valentin. You knew that Valentin was going to test, not you, but trial counsel knew that Valentin was going to testify.
Right.
Knew the content, I assume, of what Valentin was going to testify.
Right.
So it's not as if the thought of interviewing this key witness would not have occurred to trial counsel. The only thing that was learned, which I agree is important, is that this was a CI.
Right.
But it's not as if it wasn't perceived that he was a key witness before trial. So I don't understand why you're saying he would have spoken to him if he knew he was a CI.
Right. Well, I think
he wouldn't have tried to speak to him if he knew that he was simply going to report that 2 days earlier, Mr. Molina had invited him to join him in a murder robbery.
Right. I think that when you go to the trial court said that this was not an easy issue. The trial court concluded that the undisclosed information was material. It went to credibility. It was exculpatory. And the trial court considered mistrial, and the trial court considered exclusion of the testimony, and decided that what the third option of trying to put the defense in the same position that it would have been had they had timely disclosure that was the route that the trial court took.
I take it, though, there's no evidence here that Mr. Valentin, who had from time to time passed information on to the police, no evidence that he received anything of value in connection with his testimony in this case or providing information in this case.
No, but he did when he testified on voir dire, he did testify that sometimes the police paid him money and sometimes they gave him benefits in his drug dealing cases, which were many. But again, the issue here, as Judge Cowan points out, is it's prejudice. I mean, that's what it boils down to. Was the defense prejudiced by this disclosure in the middle of trial? And I would say to you that they were. That the informant relationship implies compensation, even if it's not specific to this trial. Counsel argued cogently that the difference between pretrial and now is that right now he's doing it by the seat of his pants. He's on the fly, and that's really hard to do in the middle of trial. The trial court felt that the issue of prejudice was close, but the court considered that it had been cured. The second Brady issue is the police report. In addition to the non-disclosure that Valentin was a police informant, the prosecutor also failed to disclose that out of the 91 fingerprints that were lifted from the scene, only the two co-defendants' fingerprints were found in blood. That withholding of information came in the middle of cross-examination. So not only was it in the middle of trial, it was the middle of cross-examination. And the way it came in...
Explain that again to me.
Well, the way it came in, on direct examination, this fingerprint witness identifies Molina's print on the knife handle, Molina's print on the steering wheel, and the co-defendant's print on the driver's side mirror. He listed and then identified all of the other identified and unidentified prints. There were 91 in all. On cross-examination, defense counsel tries to elicit that some of the prints were in blood and some were not. I mean, the defense counsel's going there. And that's when the officer admitted that there was no indication anywhere on the recovery log that the defense counsel had that identified which prints were in blood, but the expert is sitting there with his own log, which says these are in blood and these are not in blood.
Okay, so what is the big, I understand some prints are in blood and some aren't, and I gather from reading the briefs and from your explanation here that the defendant wasn't told that there were some handwritten notes of the expert, that some of these
that the
weren't in blood.
The only prints that were in blood were these guys.
Right. So what difference does it make? Since a fingerprint is a fingerprint, it's more inculpatory if it's in blood, but what difference did it make?
Well, I think it makes a difference because he said, well, first of all, it was disclosed not only mid-trial, it was disclosed mid-cross-examination. I mean, the defense counsel goes to sidebar and he says, I've looked like a fool in front of the jury. And the judge basically says, you poked your head in a hole and you got bitten. I mean, basically he did because he was going there. And had he known, he wouldn't have gone. He wouldn't have been cross-examining in that line. He argued that he was ambushed. He looked like a fool in front of the jury, made me look bad to come over here and argue this, and he says, and it prevents Molina from getting a fair trial. He said he was sandbagged.
Now, help me on this. Is this? I get the impression that basically there was a type report which everybody had, but there were certain notations.
Right. Right.
And is there any indication that the ADA had a copy of those notations? Because apparently it didn't come out in the direct of this witness.
It didn't come out in the direct of that witness, and the reports themselves, which the Commonwealth has given to you in a motion, the reports themselves were not entered as evidence, and they were not marked as exhibits. Now, whether the ADA had them or not, I don't know. Perhaps Attorney Seifel could answer that question.
Okay, so let's assume for the moment, and I think it's probably fair to say that if the ADA had them, he would have used them. I'm trying to figure out, let's assume that it had gone the way it should have gone, and the examiner had said, I've got these handwritten notes, this actually should be viewed as an amended recovery log. I give it to the ADA, ADA gives it to trial counsel.
And that's the way it should have played out.
Right, that's the way it should have been, I understand. But so if that had happened, what do you say would have been different? It sounds as if then the ADA would have on direct made the point.
Perhaps, yeah.
So the point would have been made, but it wouldn't. I mean, I understand that it's embarrassing for defense counsel, but is it substantively different for the jury? The jury is less concerned about the feelings of defense counsel.
The way it plays out. If it had played out like that, it would have been, I think, identical. The jury would have heard this, but certainly if the cross-examination from defense counsel, he wouldn't have gone there had he known this. And, of course, the state trooper of 9 years knew that the defense was entitled to the report, but he testified that he didn't give it up. Counsel moved for mistrial a second time, arguing that the remedy of additional cross-examination was inadequate.
Help me. Wasn't defense counsel permitted to say to the chemist, you were supposed to turn this over, but you didn't?
Yes.
So that he got the benefit of that, of embarrassing the Commonwealth and its witness, that they had done something wrong.
That all came out. I'll switch now to Valentin's testimony, which was unreliable and coerced. It was evasive. It was contradictory. It should have been stricken. His claim of Fifth Amendment privilege was never waived and was ignored by the court. His testimony was coerced by the court.
Did he claim the Fifth Amendment?
He did.
Did he say, I claim the Fifth Amendment?
He didn't say it in those words. But
well, how did he say it?
Cases have said that you don't have to use magic words
here.
What
did he say?
He said, first he said, I can't answer that question. I don't want to testify. I don't want to say anything. I don't want to talk about it. I don't want to answer because what I say would prejudice me.
Excuse me, but what standing do you have to raise the Fifth Amendment?
Oh, I admit that only this privilege is the witnesses and not my clients.
So
but
what standing do you have to argue?
My argument is that, I mean, I don't dispute that the privilege was the witnesses, but the fact that Valentin was repeatedly trying to claim his privilege to not testify, it's important because he was actually forced to testify.
But that isn't your argument.
Well, it is my argument. I mean, I'm not claiming my client has no standing to claim a privilege, absolutely. But it's important here because if you parse Valentin's testimony, he's trying to claim the privilege, and his testimony is different from his testimony at the grand jury, and it's different from what he said to the police. And I should go back too that what Valentin said. Richard Molina was a stranger to Valentin, which goes back, I think, to one of your previous questions. But the witness continued in front of the jury and on direct to refuse to give the prosecutor the answers that he wants. The prosecutor is trying to get him to say, basically, yes, this stranger, Richard Molina, came to me and asked me to get in the back of a car, put a wire around a guy's neck, and choke him. That's what he had said before. And he just answers the questions, no, that's not what happened. No, I don't want to answer that question. No, I don't want to answer because what I say would prejudice me. Okay. The trial judge appropriately appoints him a lawyer for the Fifth Amendment issue. The lawyer says he doesn't have a privilege. He continues to say, no, I'm not going to talk. I'm not going to answer the questions. But I would suggest to you that what the prosecutor and the trial court came to the conclusion that his whatever privilege he was trying to assert was only that he was solicited to commit a crime. And solicitation to commit a crime, and he said, no, I'm not going to do this, is not a crime. And so there was no privilege there. But I would suggest to you that the crime here could be, just as easily, it could be that he lied to the grand jury and that he lied to the police.
But
and
he had a lawyer was appointed for him.
Right.
The lawyer said there is no Fifth Amendment
Right.
privilege here.
Right.
I mean, all of that was vetted and ruled on.
It was.
How
It
can
was.
we be arguing this here?
But I also think that this is a witness who is marginal. He is a long time.
Unfortunately, a lot of cases have to be made with. I mean, who
This
else
is
do you
true.
ask to kill somebody?
Exactly.
Right? You don't go. I mean,
Exactly.
find somebody who's marginal.
Exactly. But he has a limited education. He was a longtime drug user. He was on SSI for psychological problems. And he had this deal with the police that he would give them information, they would give him money and turn the other way with his drug deals or something like that.
And all of that was brought out.
And all that was brought out.
Cross-examination, so the
All that
jury-
was brought out. So he's this, marginal person who has a limited ability to understand. But I would suggest that it's just as plausible that he's trying to tell the truth in this trial, that these events didn't happen, knowing that he had lied before, and that in his mind this is the perjury.
Can I? Okay. What are the principal differences between his grand jury testimony and his ultimate trial testimony?
Well, his ultimate trial testimony was the same. And interestingly, that his ultimate trial testimony he was on voir dire twice.
Right.
First to determine if he had a privilege, and second to determine if he could be treated as a hostile witness by the ADA. His actual trial testimony came out the next day, and I would suggest, after he was prepped for it, in between, and the next day he doesn't do this. He didn't have to be treated as a hostile witness. The ADA asked open-ended questions, and his testimony was the same. This stranger, Richard Molina, came to him and asked him to sit in the back of a car and put a wire around somebody's neck. Whereas the day before, he refused to say that over and over and over again.
Now, can't we infer that the jury did not give that much credit to Valentin's testimony because they found the defendant not guilty of deliberate premeditation? I mean, if they had believed Valentin,
that's true.
wouldn't they have found him guilty of deliberate premeditation?
That's true.
Since
Then
this
it
was
would
the
have. That's
classic.
true. That's true. It would have been classic. That's true.
So if the jury understood that Valentin was not terribly credible,
Yeah, yeah.
what should be our role to accentuate that? I mean, the jury already
Yeah.
said we don't really believe
Right.
beyond a
Right.
reasonable doubt that conversation took place,
Took
because
place.
otherwise we would have found him guilty of deliberate premeditation.
That's
We didn't.
true.
We found him guilty of
That's
extreme
true.
atrocity.
That's true. But the reason why this is important is because, other than the fingerprints, this is the only other evidence at all. This is a
Well, you
case.
got the cell phone calls.
The cell phone-
The
the
timing
cell
of the cell
phone-
phone calls is
yeah.
not terrific for your
The ce-
client.
the cell phone, my client's caller, my client's cell phone number, which he shares, a phone that he shares, was on the victim's caller ID. But again, the privilege that I would suggest that Mr. Valentin was trying to exercise was that he was a drug dealer. He was a drug dealer and a distributor, and he was exposing himself to perjury. So it's a twofold. I think
Well,
in
the
his,
police well knew he was a drug dealer.
That's
I mean,
right.
They were
Oh,
using him
yeah,
for
they used him
years
all
and
the
paying
time.
him.
That's
So
right.
he wasn't really going to incriminate himself much more.
That's right. Except that there are cases that say that even the thought, if there's a possibility that the Commonwealth won't indict, it's still you could claim a privilege. And the cases also say the privilege should be granted, freely granted, if the witness is trying to claim the privilege. And of course the issue here is he trying to claim the privilege? And I say that he is.
Refresh my recollection, did your client give a statement
No.
to the police?
No. He did give a statement, but he did give a statement, but it wasn't at all.
I thought part of his statement was that he didn't know
I'm
the
trying to remember the
victim at
statement.
all.
Yeah, I don't think the
And
statement.
that's why the cell phone calls between the victim and
That's
your
right.
client were
That's
of
right.
some relevance?
That's right. And finally, if nothing else, the trial court should have stricken Valentin's testimony altogether because Valentin's repeatedly exercising this right to testify was prejudicial in front of the jury. Cases have held that it's prosecutorial misconduct necessitating reversal for the prosecutor to question a material witness in front of the jury to provoke a claim of privilege and then
Well, that
rate.
surely wasn't the prosecutor's
And I'm not
intention.
claiming that now, but I'm saying this is how far the cases go. And this is not a claim of prosecutorial misconduct. It's just that this is how far the cases go in saying that the witness's privilege should be exercised or should be protected if it's exercised. Okay. Secondly, the trial court invaded the province of the jury with respect to the Valentin testimony. In instructing Valentin about his Fifth Amendment privilege, the court kept telling him, you may not lie under any circumstances. Knowing that he'd already lied, the trial court kept pressuring him to, quote, tell the truth. Some of this was outside of the hearing of the jury. Some of it was before the jury. But by doing
I'm
this...
sorry, did the judge say to Mr. Valentin in front of the jury, you may not lie, sir?
I think that was outside the presence of the jury.
I would think so.
Yeah, I think that's right. But by doing this, the trial court was making a preliminary assessment of Valentin's credibility, finding it wanting and warning him not to persist by reminding him of the consequences of lying. Effectively, if Valentin testified that there was a conversation about the cord, then he's to be believed, and if he denies it, then he's to be disbelieved as far as permitting perjury in a murder trial. If he says, and this is a quote from the trial, if he says, yeah, there's a cord conversation, this is from the defense counsel, he's okay, he's a good guy, he's truthful, but unless he says that, he's lying. This is not what the process is supposed to be like. The court and the prosecutor were determining credibility under these circumstances, and that's not the way that it's supposed to play out.
So what should the judge have done?
Well, I think he
in a
should have-
circumstance where you have somebody who is an voir dire all over the place.
I think he should have stricken the testimony, and then which gets me to my last
should
point.
what?
Should have either stricken the testimony, not let him testify, or claim.
Well, is it up to the judge to decide who's being truthful? Isn't that an issue for the jury? I mean, if we strike all the witnesses' testimony that isn't truthful, we might stop having trials.
Well, except that just the way it was coming in with the voir dire, where he was refusing to testify, and the judge and the judge and both the attorneys knew how he had testified before, and now he's just refusing to say that, which leads me to think that he was lying then, and now he's trying to tell the truth, but afraid of a perjury conviction. And finally, with respect to Valentin's, and my time is up. Valentin's testimony lacked all indicia of reliability, as I said before. First of all, it was impossible to tell which of these versions was true.
And your time is up.
All right, thank you. I'll rest on my brief for the rest of my arguments. Thank you.
Good morning, Mr. Steinfeld.
Good morning. May it please the Court, Kenneth Steinfield for the Commonwealth. Starting with the first issue, the disclosure at trial that Valentin had previously been a CI. I would first like to note there was no evidence that he was still a CI at the time of trial. The only
What
evidence
difference
was...
does that make?
Well, I just wanted to correct a misimpression that something my sister said. I just wanted that known. So he was not currently an informant at the time of trial. The only evidence was that he had been.
What does that mean? Meaning that when was the last time he had given information and been paid for it?
Well, there's no evidence of that before the record.
So
But I'm saying that there was less prejudice or less potential for there to be prejudice. Bias, for him to be biased, because there was no evidence that he was continuing to be a CI for the government. But it's a very minor point, Your Honor.
All right, but it's not clear how you can say he's not presently a CI when you can't tell me when the last time it was that he was giving information and been paid for it.
Well, I just said there was no evidence that he was currently a CI. The prosecutor did tell the judge, I do not know whether or not he is currently a CI.
So we don't know one way or the other.
That's right, but I don't think that it ultimately matters. The sole question is really whether Judge Whitehead abused his discretion.
No, Mr.
when-
Steinfeld, it's really not the sole question. This is not the only case that we are hearing today, and it's not the only case, and this unfortunately is happening rather repeatedly. Namely, the Assistant District Attorney says, I didn't know, I asked, but I wasn't given the information. It could be a police report, it could be the disclosure that somebody's an informant. Nobody's claiming that this isn't, well within Brady, correct? You don't take the position that this isn't covered by Brady.
No, that's correct. I do concede.
So what do we do, Mr. Steinfeld?
Well, I think this
Just
court.
Yeah, go ahead.
Well, here there was no showing that the prosecutor himself knew about the.
I understand that. We have
report.
prosecutor after prosecutor with good faith standing up here
Sure.
saying they asked and they were told there was nothing. Well, if that's going to be the case, don't we let defense counsel perhaps do their own discovery? Why do they have to go through the prosecutor? I know that's our law.
Yes. Well.
Should it be when we keep getting cases where they ask and they don't get the information?
I don't think that in all cases. I think if there's an intentional withholding, I think
No,
that's another thing.
not intentional. In civil cases, which are far less important in some respects, you don't have any intentionality. You let defense counsel get access to the records.
Sure. Well,
Here we have a state trooper, experienced, knows he should tell it, and didn't hand it over to the prosecutor. Oops, we say, well, we actually look at it through hindsight, no problem. I
well,
mean,
the state trooper here was not part of the prosecution team, although there was evidence that Valentin, because he went to his handler, his drug handler, and told the handler.
Commonwealth is the Commonwealth is the Commonwealth.
Sure, but in terms of the prosecution's obligation to find and turn over exculpatory evidence, it is limited to those who are on the prosecution team. The state trooper had nothing to do with this case at all. So the prosecutor himself only found out shortly before trial while he was prepping the witness, and he promptly turned it over. And the law, and while it's unfortunate that these cases keep arising, I think the law has to be for justice to continue, for these cases to go on, for the law to be whether or not the disclosure was sufficiently timely for the defendant to be able to make effective use of the information.
You don't challenge that we have a higher standard of review with respect to looking at it when there has been a specific request and a non-disclosure, correct?
That's correct, but here there was no specific request. There was a general request, and Judge Whitehead ruled below that it was a general request. He didn't ask for any information about whether or not Jose Valentin was a CI, and certainly he did ask whether there were any promises, rewards, and inducements for this case, and he knew that there were none.
Well, that goes back to Justice Gantz's question. If we don't have any indication whether he was continuing to be an informant, how do we know that there were no promises or inducements?
Well, we know because of the voir dire that occurred and the interview with Sergeant Canty, and there was no evidence then, and there still is no evidence that he received anything for this case. He came forward a few days after the murder because he thought he had information. He heard that the victim had died, had been strangled by a wire, and he recalled the conversation that he had, so he went to his handler, the state police officer, Sergeant Canty, and the prosecutor said on the record that he learned of it during his prep for trial. And so
he doesn't know Molina. He hears about the circumstances of a homicide. He goes to the police and says, oops, I just remember I had this set of circumstances.
Well, He goes to the state policeman that he knows from his drug informant work, rather than the police who are currently investigating this case.
Right. So he's hoping to get something from his drug informant handler.
Well, there's no evidence of that. We don't know. I mean, one could infer from his longtime habit, both being a drug addict and a seller of drugs, and his longtime status as an informant, that perhaps he harbored in his head some hope that by testifying he would get some benefit, some unknown benefit in the future. But as the Tevlin case points out, that does not make him a government agent.
Isn't part of the problem here, as far as the Commonwealth's revelation of the information, that someone who's a confidential informant is that information is treated very confidentially? So the trooper who was his handler wasn't revealing it to everybody. In fact, was probably revealing it to almost nobody. And isn't that what causes some of the problem here?
Well, I don't know what exactly was in Sergeant Canty's mind. I know that when dealing with CIs, obviously, there is that extra layer of caution. Judge Whitehead said that he wasn't even...
Which gives way when you're going to offer up somebody as a witness.
Pardon me? I didn't...
Which gives way when you're going to offer up somebody as a witness, which any reasonable state police officer should know. I mean,
That's
do we
true,
have...
but is there any evidence that this officer who was his handler knew that this Valentin was going to testify in this trial?
Well, no, but there was evidence that the informant later met with a state trooper who was involved in this case, and with an officer from the Methuen police.
Well, of course,
So
it makes
people
sense.
on-
If
Right, so
Mr.
people-
Valentin goes to his state police officer handler and gives him this information, obviously
But
that
he's not going to keep it to himself.
information given to the police that are working the investigation, then he's turned over to them. I mean, that's an obvious linkage.
Right, and I think it's fair to assume that that happened pretty early on after the murder, but that information never got to the prosecutor, which of course it should have.
my questions are going to what do we do when we keep having this, and essentially defense counsel have to go through the prosecutor. And my question is, if we continue to see this, is that how we should be running, what our rules of discovery are?
Well, no, I don't think so. I think that the rules should continue to be that except in cases of the intentional withholding of obviously exculpatory information.
How do we establish intentional withholding when the prosecutor didn't even know?
Well, if the defendant could show that it was report in the officer's possession or in the prosecu's
No.
possession,
There's
and
no
it's
claim
something that's obviously exculpatory. I'd like to correct one other thing. Judge Whitehead, the thing that Judge Whitehead was not sure about was whether or not this was even exculpatory. He never evinced any doubt on the record that the remedies that he imposed would cure any prejudice. He said on balance and out of an abundance of caution, this information might be exculpatory because it might go to bias, and therefore, out of caution, the prosecutor should have disclosed it earlier. So this is not a case in which you have evidence that is clearly exculpatory, as I say, citing the Damara case. This was, in fact, thin gruel. This is not, this is not evidence that from Valentin that he said, yeah, I gave the name of some other guy, and that guy went and did it, or no, I did it myself. It's nothing like that. It's the mere fact that for $20 a pop, he provided information to a state police officer in drug cases. So I think that to reverse in this case, because of the failure, obviously regrettable, for that information to get where it should have gone, would cause a backlog, would not serve the administration of justice very well.
But isn't this actually a bit harder in this case? Because this is not a situation in which a CI turns out to be a witness to a murder, testifies, and his handler has no idea that the CI was a witness to a murder. This is a case in which the handler himself learns the information. I assume the handler then passes it on.
Right, passed on Valentin to, to
So
the
the
officer.
handler knew that he was a CI, and he knew that his CI had given them information, and the handler passes the information on to the police, and therefore very well knows that he's a key witness
Certainly.
in the case. So isn't that more problematic, since then that meant that the state police trooper said, I've got somebody who told me something, but didn't say, by the way, we
You should
have
know.
an understanding, he's being paid $20 a pop, and we're not prosecuting him for drug use?
Well, they considered the key information from Valentin, and I think fairly this guy came to him and said, Molina came to me 2 or 3 days before the murder and offered me money or drugs to put a wire. He said, oh my God, you should talk to the officers investigating. It probably didn't occur to the state trooper that the fact that he'd been an informant for him in drug cases had anything to do with it. So,
I decline to accept that. It didn't occur. That's not our standard, whether it occurs. He's going to be a witness.
right, but the officer, the state trooper who turns him over to the investigators, just told him, from all we know, that he was solicited by Molina. We have, it's well, I can't say that it seems likely because that's too speculative, but there's no evidence that the information that Valentin was an informant for Sergeant Canty was ever passed to anybody on the prosecution team. They just knew that he had witnessed that he had been the object of this solicitation.
Well, I guess
Knew
part
that
of the
he
issue
said
is,
he'd been they knew that he said he'd been the object of the solicitation, and I would assume, amongst nothing else, that a prosecutor might think about whether you use that person as a witness when you know that what he's doing is looking for opportunities to get paid money to give information.
Sure, but I think that's a judgment call that is ordinarily made by prosecutors, not by police.
Well,
it's not so
a
obvious.
prosecutor can't make that if the prosecutor isn't told the information by the state police in the first place.
Sure, that's true.
So
but I
you
think
stand here and say, well, you know, it's all an administration of justice, and for all we know, a decent prosecutor might not even have called Valentin, then we wouldn't have all the problems that we have here.
well, we definitely needed Valentin as a witness.
And you did make the decision to call him the next time.
Oh,
In
yes,
this
of
case.
course. Oh, yes, he was a
Co-defense
very
case.
important witness in both cases. We agree that although the bloody fingerprint is hard to get around on the murder weapon, and also on the vehicle itself, the palm print on the steering wheel, those are hard to get around. I'd like to move on to the Fifth Amendment issue, unless the Court has any further questions on that one. There are three things that the defendant has to prove to prevail. First is that he is standing to assert the Fifth Amendment rights of another. The second is that the witness actually asserted the Fifth, and the third is that there was a valid Fifth Amendment privilege that Judge Whitehead overrode. Here he doesn't even get past the first. He simply has no standing. My sister conceded that he has no standing, so I'd ask the Court to stop its analysis right there and not even move on to the second and third questions, though I do spend a lot of time in my brief explaining why were the law otherwise, and if the defendant did have standing, he would still lose. So I think the standing, the lack of standing alone, I think, should decide this claim adversely to the defendant. Valentin never asserted a Fifth Amendment privilege, either personally or through his attorney, Mr. Landy. He made clear repeatedly that the sole basis for his reluctance to testify was fear for his family. He did state at once, I don't want to talk because it might prejudice me. Judge Whitehead then asked him explicitly, are you saying that you do not want to testify because you are afraid that you will incriminate yourself? And he said, no. He also was told several times, you do not have to testify if what you will say will incriminate you. And he testified anyway. He had he spoke to his counsel several times during his testimony. He spoke to his counsel prior to his testimony, and that attorney, Mr. Landy, said 2 or 3 times, there is no Fifth Amendment issue here, Judge, that I see. So the notion that the witness ever asserted a Fifth Amendment privilege, he certainly said, I don't want to testify. He made that clear. We all knew that, but this Court has held several times that a fear for oneself or for one's family is not a valid basis to refuse to testify. Thirdly, there was no valid privilege to be asserted, as Judge Whitehead held, although I'd say his holding was somewhat dicta, if you can say that, of the trial court. He said, first, I don't think you have standing, but I don't want an appeals court to think that I'm not thinking about it. There is no privilege because simply being asked to commit a crime and saying no, that could not possibly incriminate him. But as to the standing issue, I think it's interesting also that Judge Whitehead ruled 7 times that there was no standing, and yet my opponent does not mention the issue in her brief at all, just skips to the second and third part and also failed to file a reply brief on the issue, thereby suggesting that the lack of standing is dispositive. Thirdly, the claim of the fingerprint report, and I have filed this week a motion to expand the record to include those reports. I think they should have been marked for identification, and I think the fact that they were not was purely out of inadvertence. They were certainly the subject of discussion at trial, and in fact they formed the entire basis of the claim. So while these documents were described with some particularity in the transcript itself, I think it might be helpful just to have the documents in front of them. On this claim, I'd like to point out primarily that the sole claim asserted on appeal is a chronic claim. That is it. That claim was never brought below. This is obviously, this is not, in my view, a chronic situation, because the defendant was not denied entirely the assistance of counsel, nor did his counsel fail entirely to subject the Commonwealth's case to adversarial cross-examination. Here he did, in fact, cross-examine Trooper Handley extensively about the report and got him to admit that he had not given it to the prosecutor, he'd not given it to the defense, although he knew that he had an obligation to do so. So I think there was no...
I'm not going to go through the whole list of questions again, Mr. Steinfeld, but I'm noting them.
Yes, yes, of course. It is the same type of situation. But the information that the defendant claims was not disclosed to him was available to him, and he sent a fingerprint expert to review the actual fingerprints himself, and therefore should have known before trial which of the fingerprints were in blood. And
Well, surely, I take it the only fingerprints that were in blood were the fingerprints of the defendant and the co-defendant.
Yes, that's
if I got
correct.
that wrong.
yes, that's correct.
So when the defendant's expert went to examine those fingerprints, I assume he would have known that they were fingerprints that were taken in blood.
That's correct.
Left in blood.
That's correct. I think that's a fair assumption. And I also think, although in this case perhaps not, but I hope so, and I'd like to think so, had the other fingerprints been in blood and belonging to somebody other than the co-defendants or not identifiable, then that certainly would have been highly material exculpatory information that would have been disclosed by the prosecutor. So while I don't doubt that the defense counsel did not know at trial that the other ones were not in blood, that information was certainly available to him, and he suffered only minor embarrassment. And I don't think that Judge White had abused his discretion when he said that that embarrassment was offset.
You've just said something very interesting. You assume that if one of the other fingerprints, one of the unknown or unidentified fingerprints had been in blood, that surely would have been disclosed. But in truth, that surely would have been disclosed only if the prosecutor knew about it, which means only if the police gave the prosecutor the information.
Right, that's correct. But
And the prosecutor didn't, or excuse me, the officer didn't give the assistant district attorney the log in which he had noted which ones were found in blood.
right, but I think that it would have been a different case if there had been. That's only because the only 3 prints were in blood.
Okay.
Were there a lot of other fingerprints also in blood, it seems likely that the prosecutor would have known about it. The only reason that he didn't know about it, well, the prosecutor knew which ones were in blood. And as Judge Whitehead said, the defense counsel took a chance and he followed a line of questioning that didn't work out. And in exchange, the Commonwealth was held. The jury was told explicitly that it failed to meet its discovery obligation.
The ADA, you say, knew which ones were in blood and failed to bring that out in his direct?
He did.
He did bring out in his direct?
I'm sorry. He brought out the ones that were in blood that belonged to the defendant and the co-defendant. He did not go on to say whether or not the other ones were in blood. He just said these 3 are in blood. There are 16 that are identifiable, 94 or so total, 3 of them in blood, all belonging to one of the defendants. That's what he brought out. Finally, as to the claim of the
So it did just, again, I'm
Sure.
sorry, what was it that was not revealed beforehand?
well, it was not
I know it was the
explicitly.
notes in the log, but exactly what did they establish?
Well, the log, as I have submitted to the court, has in the left margin, well, it's a list of 94 fingerprints that were found. And there are categories for each of the fingerprints. It says where it was found, who took the print, and to whom it was identified, if it was identified. The log that the expert had at trial that had not been turned over had in the left margin, next to the 16 prints that were identified, the word blood in handwriting or not in blood. And sometimes it said NIB instead of not in blood. So he merely, from his own memory and knowledge of the case, while preparing for trial, put those there so he would know which ones were in blood and which ones were not in blood. There should have been, there's a notes line on the log where presumably it should have been put in blood, not in blood, but that's just not how they did it. I see my time is up unless the members of the court have any further questions. Happy to rest on my brief.
Thank you, Mr. Steinfield.